May it please your lordship, my lord, I have to mention for listing in order column, my lord, for paying for my lord, extension of time, my lord.
Okay. Prayer for listing, please give it to the court master.
My lord, my lord.
May it please your lordship. With the concern of other set, I beg to mention item number 10.
10 and 12, no? 11, 10 and 11.
10, 9, 10.
9 and 10.
9.
I'm for the appealant, madam.
Lordship, in item number 9, I am appearing for all the private respondents.
My lord?
Land
Yes,
acquisition.
Aizawl bench, madam. I related, madam. Those were transferred here. No, we filed because another earlier another was filed, madam, when there is no bench, madam. Then thereafter we filed another was transferred to here, madam. Two, madam. So, my lord, this petitioner, he's out of station, my lord. We propose to, my lord, if lordship, my lord, the 13th of this month, my lord. 13th of November, my lord. Because there is another requisition pending series of requisition, my lord. Stay order also there in. Okay. Your name?
SRA Nasir, lordship.
You're there on record.
On behalf of PD Nair, lordship.
Okay.
Item number 10. For a respondent.
Okay, all sides are represented. On the prayer made by Mr.
SRA Nasir, on behalf of
SRA Nasir, on behalf of Learned Counsel, on behalf of Mr. PD Nair, counsel for the respondent number 1 in
All-
WA 320 or 2023. The matter stands adjourned today. List on 13, my lord. No, 13 is difficulty. 1911.
1911.
19, my lord, I will out of station, my lord. The person, and matter on, my lord, 28, my lord. Then 28.
Eight or 20.
28 released. Not now. 22 to heavy metal. Wednesday.
28th
28.
November. High levels.
Highly appraised.
28. Just on 28th of 9.
May it please your lordship, with the consent of others, I give the path of. Well, item number 29 to 31, my lord. My lord, already affidavit in reply was filed. Thereafter, he filed an additional affidavit by giving some documents which are against me, my lord. So I want to file reply regarding that issue, my lord. 29, 30, and 31, my lord. They filed an additional affidavit file. So I want to file reply regarding that issue.
All sides are represented. On the prayer made by Mr. N. Barak, Learned Counsel for the petitioner. The matter says adjourned, unable to file the affidavit in reply in the matter. List after 2 weeks.
My lord, fix a date on 12/11.
They're not fixing a date. Make a mention if it is not listed. Normally it will come in 2 weeks.
Thursday,
Because all-
Tuesday.
All foreigners matters are being displaced, so we have.
No, this is not a foreigner matter. my
No,
lord.
I understand, but we are taking up
Oh.
that bench, so this.
My lord, at least, my lord,
You
November.
make a mention if it is not listed. Make a
any date,
mention.
my lord.
May I please your lordship? So item number 6. Lordship. Item number 6, lordship. I need some accommodation, lordship. I could not contact my client, lordship. It was being engaged by somebody, lordship. One of my colleague, lordship. He left. So give me 3 weeks time.
What says it? List after 3 weeks as paid for by Learned Counsel for the petitioner. Yes.
May I please? Sorry, may I pray for listing one?
Listing give it to the court master.
tomorrow, Lordship, as a motion, Lordship, because date is fixed for judgment on 29th, Lordship, and the additional witness evidence for additional evidence, Lordship, it was rejected, Lordship.
Okay.
So may I pray, Lordship, listing the
Okay.
matter tomorrow?
Permitted.
March.
Yeah, please. I need to mention action number 4. Pay for adjournment.
Or is it 2017 matter?
Madam, only.
Okay. After 2 weeks, as paid for by land council for the petition. What says the representative? Okay.
I beg to mention item number 5, Lordship. Due to some personal difficulty, I pray for an adjournment today, Lordship.
2017 matter.
Lordship.
Okay. 2 weeks.
Obliged, Lordship.
Wait, please, your lordship. I beg to mention item number 8, lordship. Kindly matter may be adjourned for the day, lordship. The senior is out of station, lordship.
Okay, same order, item 8.
Obliged.
May I please, your Lordship. I beg to mention item number 2, your Lordship. English
Yep.
English counsel is unaware, your Lordship. He could not come to the court, your Lordship. He instructed me to adjourn the matter for the day, your Lordship.
Okay, 2 weeks. Item 2.
Highly obliged.
Supply item 32 for motion.
May it please, your Lordship. My lord, last order was there for calling of the records.
I got the record.
Item 1. Item 1.
My lord, what I want to place, my lord, your lordship will find the notice was served where it was stated at page 41 by the by the particular. Yeah, left the village, and thereupon, my lord, another proceeding as per 3F, my lord, under the Foreigners Tribunal Act, it should be affixed in the last place of residence. My lord, he has left the village at the place where he has last resided. That place has to be affixed. My lord. My lord, here what I find, my lord, but I'm reading that particular provision. It is, my lord, the Foreigners Tribunal Order 64, 3F. Right, here it is written, my lord.
It is here only.
Here it is there. If the proceeding has changed the place of residence or place of work without intimating to the investigating agencies, the process server shall affix a copy of the notice on the outer door or some other conspicuous part of the house in which the proceeding originally resides or last resided, or reportedly resided or personally worked for gain or carries on business, and shall return the original to the Foreigners Tribunal, from which it was issued with a report endorsed thereon, or annexed thereto stating that he was so affixed the copy. That is 3F. Foreigners Tribunal. Procedure for disposal of questions. 3F. And the report is at page 45, madam. It is an undoubtedly, my lord, expertise. My case was that I am not that person, my lord. If the person has left, I reside in a nearby village in Borpeta district. I was called by the Borpeta police, then, my lord, I was put in detention camp in Gwalpara. Father's name is same, my lord. Your lordship will find from the documents at page annexure 1 onwards. Father's name and page 16 onwards. There from 66 onwards, I have placed all my documents. My grandfather's name, then, my lord, my sale deed, everything was there, my lord. Aadhaar card, PAN card, everything is there, my lord.
No, but
Election.
you never appeared before.
Because, my lord, notice was never served to me, my lord. Address village is different, my lord. Dimapur and Moja is Rupshi. And whereas, my lord, in the judgment, your lordship will find that is his place of residence is by Borpeta is Anwar Hussain. Please, sorry. Torbok, village Ghugubari. Page 37, paragraph 2, village Ghugubari. My village is Rupshi, Dimapur and Moja Rupshi.
Rupsi in Dimapur.
My lord, Moja Rupshi, village Dimapur in Borpeta district.
Dimapur.
Dimapur, village Dimapur, my lord. Page 37, your lordship will find the person in that reference is residing in village Ghugubari, PS Shorbok, district Borpeta. And my PS is Kolgachia. And notice was always served at village Ghugubari, PS Sorbo.
Where is the Gaupura certificate?
My lord, the Gaubra original is at page 50 and my lord, the type copy is at page 49. In my favor.
No, the certificate issued stating that you had left the village is not available with you.
No, my lord, we got it from the certificate copy we obtained from the record. At page 42, your lordship will find that it was returned, the notice was served and it was, report was, it was returned to the court. Page 42 in Bhandakula.
Yes, my lord. One aspect your lordship may kindly say, if my learned senior friend is arguing that the notice was not properly served, I have no objection on that. But if he says, my lord, my lord, it should be fair enough, whether he is the same person or not, whether he. Yes. That is wrong, my lord. That's why I'm saying, my lord, he should be fair enough, because the father name is same. Yes. Yes. Now, my lord, if the petitioner was sometime, my lord, somehow he was residing at Ghugubari village, he should have mentioned it, my lord, because. Yes, his stand is, my lord, but I have some documents, my lord, where even the wife name is also recorded the same name, my lord. Yes. So no, my lord, if he is not disputing that, I have no question on that. Yes, then we'll have to
In the
file it.
alternative, because I am behind the bar, my lord, your lordship may remand the matter and I will go.
That's why I'm saying, my lord, he should come, because proceeding, he should come with fair manner. My lord, if he says I'm not the same person, my lord, it's a different.
See, once we have to, if we remand the matter, the order has to be set aside.
then the trial, the proceeding begins on a clean slate. Now, whether he takes X objection or Y objection is for him and his counsel to decide. And tribunal will accordingly pass an order.
Yes,
We can't say that you were remanding the matter back only on the ground that the proceeding will proceed in this particular parameter. That will not be fair. See, even if we take your stand, fact remains that notice was not served, as is ever apparent. Gaubura has given a certificate. There is no, I think, examination of the Gaubura or the process server. So, therefore, on that point, on this.
yes, my lord, I am accepting that, my lord, that the service was not proper.
Right.
So on that ground, your lordship may remand it.
But whether he is the same person or not,
That-
whether he'd like to take an objection, that we can't restrict him to do. We can't object the state from raising an objection.
Yes, it can, my lord, only my lord, what, for my lord, my satisfaction and my lord, learned friends, my lord satisfaction. As he's raising that I am not the same person, my lord, I am delivering. Otherwise, my lord, I have no objection if your lordship remand the matter on that ground that notice was not properly served. Not on the ground that he is not the person.
We are not deciding that.
Yes, if your lordship ignoring that part, my lord, your lordship may remand it. I
No,
have
we
no
are not,
objection.
we are
We're
not
not ignoring
ignoring
it,
or
sir.
accepting. We are
Yes.
interfering on the ground that we find
The
notice was not served.
properly served. That must, I have no objection.
But he will also like to
Yes.
add that he is entitled to take up any objection.
He can, my lord, he can take that issue. Definitely, he can take that issue in the tribunal.
But Mr. P.K. Roy Choudhury, learned counsel for the petitioner, also heard Mr. J. Pang, learned standing counsel for the respondent numbers 2, 4, and 7. CVC, who is there? Mr. P.S. Local and CVC appearing for respondent numbers 1 and 6. And Mr. P. Sharma, learned government advocate appearing for respondent number 3. And Mr. H. Kulil Leonard, counsel appearing on behalf of Mr. A.I. Ali, standing counsel for the ECI. ECI is respondent number 5. Standing counsel respondent number 5. Next paragraph. The petitioner has filed this writ petition under Article 226 of the Constitution of India, seeking interference with the opinion dated 23/3/2018, passed by the learned member, Foreigners Tribunal number 8, Borpeta, in FT case number 74 of 2018, inter alia, on the ground that he's not the proceedee. Full stop. The other ground to assail the said opinion is that the notice was not served. In accordance with section with para 3 within bracket 5 within bracket F of the Foreigners within bracket Tribunals bracket close order, 1964. Next paragraph. Per contra, the learned Just now at the first line, it is also submitted that in the meantime, the petitioner has been detained on 2/9/2024 pursuant to the said opinion and is presently lodged at Matia Detention Center, Gwalpara. Per contra, the learned standing counsel for the Home Department has opposed the prayer made in this repetition in respect of the ground taken that the petitioner is not the proceeding. However, he is fairly considered that the service of notice was not in accordance with section with para 3 within bracket 1 within bracket small f of the 1964 order. Next paragraph. On a perusal of the records of the learned tribunal, as produced by the learned standing counsel for the Home Department, it is seen that the process server has returned the process on the ground that the petitioner has left the village along with family moreover in support of the said stand, certificate of the Lord Gambura without bearing any date is also made a part of record in indicating that the petitioner has left the village. Next paragraph. The requirement of the provision of para 3 within bracket 1 within bracket small f the A and F 15A and 15F are as follows. Next paragraph. Accordingly, it appears that the prescription of the provision of section of para 3(1)F is that even if the proceedee has left the village without intimation to the investigating agency, the process server is required to affix the copy of the notice on the outer door or some other conspicuous part of the house in which the proceedee ordinarily last resided. Post office said procedure having not been followed, the court is of the considered opinion that in order to provide a fair chance of the petitioner to defend himself, the matter is required to be remanded back to the Foreigners Tribunal, number 8, Borbetta. Next paragraph. Accordingly, the court is inclined to set aside the ex parte opinion dated 23/3/2018, passed by the Foreigners Tribunal number 8, passed by the learned member, Foreigners Tribunal number 8, Bapeta, in FT case number 74/2018, arising out of IM within bracket D, bracket close T, reference case number 8527 of 1998. Next paragraph. However, taking into note that the petitioner is presently under detention, the court is inclined to provide that the Superintendent of Police within bracket bottle, Bapeta, shall secure the attendance of the petitioner, namely Anwar Hussain, from the Matia detention camp at Gwalpara. And on his furnishing a bail bond of, on the petitioner furnishing a bail bond of is 5,000 with one surety of like amount to the satisfaction of the Superintendent of Police within bracket border, Bapeta. He shall be released on bail with those conditions, iris and all. As well as all documents for appearance. And thereafter, he shall be produced before the member, before the learned member of a Foreigners Tribunal number 8, Bapeta. And thereafter, the petition be released on bail. Next paragraph. The petitioner shall produce a certified copy of this order before the Superintendent of Police within bracket border of Bapeta. Within how many days, Mr. Roy Chaudhary?
But after release, I will place the certificate.
Saturday.
7 days, within 7 days.
You produce that certified copy within 7 days. Within 7 days from today. And the Superintendent of Police within bracket border of Bapeta shall do the needful within 4 working days thereafter.
No, the record has to prove it.
We will send it back.
Yes. Probably the record was collected by us. So
Yes, we'll give it to you.
yes.
Next one. The records as produced by the learned standing counsel for the Foreigners Department, Home Department is written back
If your lordship fix a date, particular date there, fix a date there.
No,
in the
because
tribunal.
Mr. Royce is seeking 7 days time.
Yes.
We are giving 4 days time to the SP to
Yes.
do the needful.
Yes.
So SP can do it on the next day also.
Yes.
We are giving them 4 days time. We are not fixing a date because of uncertainty.
Yes.
Or you suggest a date, Mr. Payam, suggest a date. 7 days from today is 31. So we said till 5th, by 5th, he shall be produced the SP before the Honest Tribunal. 8 Borpeta within by 5/11/2024
Only on producing ballot he will be released.
on production.
Yes.
On production, because those iris and all these appearance
Yes,
should
yes.
be there. We are securing that presence.
First I could First I could sorry.
We shall secure this
First-
presence. Okay, I'll add করে দিও। On the certified copy of this order being produced before the Superintendent of Police border, the said authority shall do the needful so as to enable the who is the head of this detention center? He's a jailer.
My lord, it is jailer. In fact, jailer is looking after that.
Jailer.
Yes.
The jailer and obligor, the competent authority in charge of the detention center at Matia, Gwalpara, shall hand over the custody of the petitioner to the Superintendent of Police within bracket border, so as to enable the said authority to accept bail and to produce the petitioner before the Foreigners Tribunal number 8, Borpeta.
Your lordship may not fix the date because if they cannot
We did not fix a date. You are making a prayer, fix a date. Once we fix a date, you say don't fix the date.
If the my lord doesn't produce, he does not produce the certificate copy, it will be difficult for us.
So then this doesn't
Yes.
doesn't
Yes,
happen.
but if he produce within
He has to produce. How
He has
will
to
he
produce.
get the benefit of this order?
That's why we did not do it.
yes, my lord.
We insisted that we should not give a date, but then you insisted no, give a date. Therefore, we give a date.
My lord, on appearance before the tribunal, he will be allowed to go.
Yes, he'll be released.
Will be. That observation.
We made it. We made that. Next, according to this, deputation stands closed. We have already given on bail, so
You're on bail after this. So it's a question of release.
Daily list item 1 for admission.
Proceeding.
সেইটো LCR আমাক দি দিব।
এটা আপোনালোকৰ ন?
ঘূৰাই দিব লাগিব। আজিয়ে পঠাই দিব লাগিব। এইটো record কৰি পেলাই record কৰি
comma, the court shall presume that the petitioner is not interested to pursue the matter and adverse orders may follow. List on 3010, no, make it 2810, 2024.
For hearing, part heard item 33 with 34.
You are there. Just few minutes before you are there.
Yes, Mr. Sharma.
My lord, my lord, PW one and two, my lord, their rightness, my lord, their statement, my lord, they're quite consistent, my lord. Now, 164 statement also, if we look at their 164 statement, my lord, they are, my lord, consistent, and my lord, their corroboration is also there, my lord. And my lord, as far as my lord, PWD 4 and 5. 4 and 5 also said, my lord, that they have, though they, though they were, my lord, saw the dead body in the next morning, my lord. But the regarding the injury, my lord, injury in their back said, my lord, the PW 4, my lord, the last part, my lord, I saw the injury in the back of the head and in the chest. He sustained cut injuries in back of the head. PW 4 and 5. 5 also, my lord, similar statement. 5, my lord, he Lalit Chandra Binjuar. He also said, my lord, I saw an injury on the head of the dead body, which seemed to have been caused with the handle of an axe. And my lord, postmortem, my lord, one thing, my lord, that categorically said that the incident took place within 24 hours.
Pardon me?
Within 24 hours, my lord. And my lord, examination was done, my lord. Postmortem was done on 12/30/18, my lord. In the next day, my lord.
Where is the postmortem report?
Postmortem report is in my lord. In my lord, it is in page, my lord, 73.
Yes.
My lord, examination 26/5/24, my lord, at 12:30 p.m. my lord. Incident was on previous night. My lord, page 77. All the injuries are as described are antemortem in nature. Approximate timing of the dying within 24 hours. And my lord, PW 12.
Just a minute.
IO, my lord.
Just a moment.
IO, my
Just a
lord.
moment.
My lord.
Yes, which page now?
Now, my lord, page 38, my lord. The Caesar, my lord, in his my lord, examination in chief, my lord, I seized a lathi and a rod in presence of witnesses from the place of occurrence. And my lord, the cross part down below, my lord, in the same page, that's the complainant stated before him, my lord. She further told that her husband was preparing roti chapati, that Anil Gaur came with an axe to assault her husband and assaulted him. That
You see, once you are showing us page 38,
my lord.
I seized a lathi and a rod.
Yes.
And in the cross examination, it is, you are referring that yes, the witness has said that came with an axe.
My lord.
That means the weapon of assault is not seized.
Yeah, my lord.
Whether or
Yes.
not it will be fatal.
Yes. Yes, my lord. That is one thing, my lord. But actually from their statement, my lord, there are three weapons. But Caesar was made only two. That part remains. But my lord, lathi and the rod was also used in assaulting him, my lord. That is evident from the statement of my lord PW 1 and 2, my lord. And my lord, the wife and my lord, the daughter were also, my lord, injured. And my lord, their medical report is also in a record, my lord. My lord, all the, my lord, documents, my lord, corroborated their, my lord, statement, my lord. And my lord, in the cross also, my lord, they are quite, my lord, consistent.
Yes.
And my lord, the judgment part, my lord, the para 23. May I read, my
Just on. Yes.
Yes, my lord. 23, my lord. Now from the comprehensive analysis of the testimony of both PW 1 and PW 2.
You are reading which page?
My lord, page, my lord, 52, para 23.
Yes.
Yes, my lord. Now from comprehensive analysis of the testimony of both PW 1 and PW 2. with their previous statement recorded under section 164 CRPC exhibit 1, 2 and 3, my lord. It loudly lucidly appears that both are corroborative of each other with some minor discrepancies, not going into the root of the prosecution version to shake its credibility in toto. It is a settled principle of criminal jurisprudence that a statement under section 164 of the CRPC is not substantive evidence. It can be used to corroborate the statement of a witness or to construct a witness evidentiary value of statement. 164 CRPC stands on a higher footing than statement made under section 161 CRPC. When the testimony of ocular witness, that is PW1 and PW2, receive sufficient corroboration from its previous statement made under section 164, then it can be safely relied upon and from the basis of conviction. Then, my lord, kindly come to my lord. Then 24 also 11, my lord. There are 24 also 11. And then my lord, para 30, 35. I would like to place my lord.
Yes.
35, my lord. The Honorable Apex Court in a plethora of decisions have held that it is not improper to convict an accused person on the sole testimony of an eyewitness alone, if it inspires confidence and is trustworthy and absolutely reliable. And in the instant case, all the ocular witnesses have supported the prosecution case in an cognate and lucid manner, leaving no room to infer an hypothesis of the innocence of the accused persons. So, my lord. So, my lord, that's all, my lord. I think, my lord, in my opinion, my lord, appeal has no merit and my lord may be dismissed. No, my lord.
Okay, one.
Right. My lord, as regards the appellant Madan Panika is concerned, PW2 evidence is that he made an X block. But I have already, my lord, argued on that front that the head injury, head skull is healthy. And that apart, the X was never seized. So, weapon of assault, so far it relates to Madan Panika, not seized. And the other point, my lord, my lord, want to please before order that as regards delay part, more than 24 hour, 30 minutes delay. And the doctor evidence, 48 hours. Doctor said, just doctor evidence, page 32. Time of date of birth, 2 days, as sign of ratification on body static. As per FIR, on 25, five 14 at 9:30 p.m. the offense of. And FIR was lost, my lord, on 26 at 10 p.m. More than 36 hours at 10 p.m. And postmortem was done, my lord. Postmortem conducted on at 12:30 p.m. on 26. So it is, my lord, about 36, but doctor's evidence, your lordship will find at page 32, 48 hours. And that apart, the allegation is against Joy Singh.
You see, all injuries are antemortem in nature, page 32.
Yes.
Approximate time of injury within 24 hours. And the death is 48 hours.
Page 32. All injuries are antemortem in nature. Approximate time of injury 24 hours.
Within 24 hours. Time of death over 2 days, 48 hours as sign of putrefaction on body started.
So it, in my understanding, that cannot be. If injury is 24 hours, how can then after that injury? Person died before 48 hours. Injury is 24 hours.
We go by what is there. There is no cross-examination.
Yeah.
It's not never questioned. Injuries within 24 hours, time of death within 48 hours.
It is in our favor. Therefore, we have not cross-examined on that part.
But that's okay. Whatever is there is there.
And the acceptability of the PW evidence of PW, my lord, 1 and 2, I have already placed reliance on 2-3 judgment, that they are unnatural because they went to the house of Keria and only in the following morning they went their place, leaving the person, father and husband, in injured condition. They went to the house of another. So on that count, I have placed reliance. Their evidence are not
And that about, my lord, another aspect, the person against whom the allegation of who inserted some stick or something that, my lord, that was seized, he has never brought to the trial. He declared absconder. So this is my humble submission, my lord. I'm buttressing upon my submission, my lord. My humble submission is that, my lord, the appellant Madan Pandika, my lord, is innocent. I am obliged.
One thing I would like to draw your attention, my lord.
Just a moment. Learned counsel for the appellant in criminal appeal number 454 of 2019, and Mr. A. Dhar, learned amicus curiae in criminal appeal within bracket J, bracket close 59 of 2020 are present, The submissions of Mr. Bankim Sharma, learned additional public prosecutor, is concluded. Judgment is
My
over.
lord, one thing I would like to draw your attention, my lord. GD entry was made in the morning, my lord. In the, my lord, from the statement of, my lord, with the PW twelve, my
Just a
lord.
moment, just a moment. In the first para, you said they are present. Their submissions in replies, in the last paragraph. The submissions of the counsel for the appellants in replies also concluded. Then judgment reserved.
Oblige.
Yes.
My lord, PW, statement of PW twelve, my lord, that prior to lodge the FIR at about
Which page?
6 page, my lord, 37. GD entry was made in the morning. Then in the late evening, my lord, FIR.
So
was-
that we are aware.
Yes,
GD entry is 26/5/2014.
yes, my lord. At 6:12 AM. At Gopati, my lord, the PW one, the informant.
12.
Yeah,
12, yeah.
yes. My lord, Bhagavati verbally informed that Tonkeshwar was murdered. On the basis of the GDF, I went to the house of that is. My lord. Ten position. Mario.
Oblige.
Item 3 or hearing.
May I please, Your Lordship? Well, interim order, Your Lordship will find. Page 34, my lord. My lord.
Yes, Lord. Yes.
My place,
In this
What?
repetition, you are relying on page
my lord.
14.
14, my lord.
Is the document proved?
No, my lord.
Then
This document, my lord, is the, my lord.
there's nothing,
Registration?
there's only exhibit 1, that is the voter ID card. Nothing else was proved.
No, my lord.
Then
My lord, lordship will see the dates, my lord. The petitioner was, my lord, issued notice, my lord. In this case, my lord, on, my lord, 31/5/17, and he appeared before the tribunal on 36/2017, my lord. And he submitted his written statements along with some, my lord, photostat copies of this annexure 1, my lord, which is the, my lord, registration certificate, my lord, of his uncle, my lord. Admittedly, my lord, the petitioner's father and their two brothers, my lord, they cross over from East Pakistan, my lord, in 1964, and they got themselves registered, my lord, along with their families, my lord. But subsequently, my lord, the documents of the petitioner, my lord, those were lost, my lord, due to a theft, my lord, in his house, my lord. And even the FIR, my lord, dated, my lord, 80 of the year 1982, my lord. Photostat copy of these documents were also, my lord, annexed in the written statement. And another document, my lord, land dispute, my lord.
No documents would
My lord,
help you
but
in your
my lord,
petition.
my humble submission is that, my lord, the petitioner was not afforded, my lord, enough opportunity to, my lord, produce this document,
No,
because if
there's-
your lordship will see
There's
to,
nothing on record to show that you applied for time and that it was refused.
my lord, petitioner submitted his, my lord, documents, my lord, on 30/6/2017. And within the next 26 days, my lord, this judgment was passed, my lord, on 26/7/2017, my lord.
You see, can we
And
interfere
although,
with
my
the-
lord, one
can-
date was given, my lord,
No,
to
no,
produce
you see-
documents, my lord,
You see, today there was a motion matter.
my lord.
At the motion stage, I allowed we allowed the writ petition. Now, can it be faulted by saying that on the day of motion it was allowed and therefore the order is bad? We gave you, the tribunal gave you time. You did not avail any opportunity to file an evidence. Your evidence was never closed or rejected. Petition was not dismissed. Prayer for time to give an evidence is not dismissed. After that, if the tribunal decides the matter, can we find fault with that order? That on the ground that you were not given an opportunity?
My lord, admittedly, my lord.
But that would mean,
Only, my lord, my
No, I
only
understand,
point,
that,
my lord.
but that would mean that the tribunal will give you a notice. You file a written statement, then it will give you an invitation card that we are pleased to invite you to the tribunal to lay down any evidence you have. We are exercising jurisdiction under statutory.
My lord. Only, my lord, the voter ID card was, my lord, produced, and which was, my lord, that is the only document. Rest of the documents, my lord, my humble submission is that, my lord, if, my lord, reasonable opportunity was, my lord, afforded to the petitioner, my lord, he could have, my lord, produced those documents before the tribunal, my lord, to prove his citizenship, my lord. And my prayer is only for the remand, so that, my lord, case may be.
What document do you want to produce?
My lord, this, my lord. Firstly, my lord, this, my lord, registration certificate, my lord.
Where is that?
This is, my lord, this is the photocopy, my lord. So if the petitioner can, my lord, show, my lord, that this is true, my genuine copy, my lord.
No, you yourself are saying, you are also saying
Also,
that this document belongs to your uncle.
yes, my lord.
So a document of your uncle cannot prove your citizenship unless you show. Now, for the second part, you say that your documents were lost. You are
My-
relying on on a FIR.
And there is also, my lord, a land dispute, my lord, in the year
That is
1972, my lord. Someone, my lord,
That is 72,
72, my lord.
but 72 is post 25/3/71 document.
That, my lord, where his father's name is shown, my lord.
No, that is okay,
Hmm.
but that becomes a post 25/3/71 document.
Prince to be a citizen.
Let's see. entered into a sum honor of the 331. Entered. Oh,
Certificate.
No, my lord. Those documents were stolen, my lord.
No, documents stolen, but particulars. Date
Particular-
of the certificate, in whose name.
No, my lord,
we
no,
should-
my lord, no.
Then which year was it issued?
My lord, along with the same, my lord, these three brothers, my lord, they crossed over from East Pakistan, my lord. And his father was the youngest, my lord. Gaurcharan Das, Nitai Das, and Jadab Chandra Das, my lord. And the petitioner before your lordship is the son of my lord, Jadab Chandra Das, my lord. And the certificate is of the elder brother, my lord, of his father, my lord, Gaurcharan Das. And your lordship can see, my lord, even their grandfather's name, my lord, Sadhunam Das, my lord, which is also reflected, my lord, in the voter card of the petitioner's father, my lord.
Where is the page number of the certificate? Which page?
Certificate is, my lord, page 14, my lord. Annexus 6, my lord. This is the voter list of the petitioner's father in the year of the year 1977, my lord. Jadab Chandra and my lord. My lord,
From which border?
you have the original of this document, page 14.
no, my lord.
No, this is something we
Not
can't
with me.
read. It's something we can't read.
My lord, here, my lord, at the top, my lord, serial number and issue number is, my lord, given, my lord. There, my lord, name is, my lord, Gaur Chandra Das, my lord. Name of father is, my lord, Sadhuram Das. Place of birth, my lord, it is, my lord, Radha Kanai. PS, my lord. District, my lord, Mohan Singh, my lord, East Pakistan.
So which is the registering authority? Who is the registering authority?
Date and place, my lord, is my not Lakhimpur, my lord, is the lower part, my lord.
Not looking.
November 1966, my lord. No.
That there is no border with the specified territory, not
Right.
looking for.
Here it is written but not Lakhimpur. And they settled, my lord, at Kohutoli, my lord.
So if you can produce some connection, some material connected to this certificate, that these particulars are available and you are.
Well, then lordship help to get me some time, my lord.
Take time, you
This
find
matter
out.
has come after a very long period, my lord. Lordship may grant me some time, my lord, so I can contact my client and in the
For that-
meantime, if they have produced, my lord, original of this
For that, you'll
document.
have to pray for time.
You did not pray for time.
Lordship, I was, my lord, praying for demand of the, my lord, matter.
So for remand, you'll have to satisfy us that there is some material which
My lord.
requires reconsideration.
Lordship may grant me some time, my lord.
You are Mr.
As per Asher.
Mr. S. Parasar, Learned Counsel, appearing for the petitioner. Mr. P.S. Locker, na?
Yes,
CKC. Appearing for respondent one, Mr. G. Sharma for respondent number two
And four.
and four, Mr. Who's appearing? Mr. Sharma.
Lordship, Lord. He's appearing for respondent number 3, Lordship.
Mr. Sharma appears for respondent number three. At the request of the counsel for the petitioner, the matter stands adjourned to be listed after 2 weeks, 4 weeks, enabling him to obtain proper instructions, enabling him to obtain further instructions from the petitioner. List accordingly after 4 weeks.
All right.
Awesome. Take a short break and come back.
Evidence.
Item 7.
Please, your lordship. My lord, impugned order at page 69, lordship. Page 69. My lord, I am declared as a foreigner without mentioning any stream, lordship. Relevant portion at page 73.
Next one. Next one.
Lordship. Lordship, from 1951, till date, all documents are there. Those were marked as exhibit. But some documents before the learned tribunal segregated. Some are marked as annexure, some are marked as exhibits, Lordship. My Lordship may kindly see exhibit A, voter list of 1966 as at page 21. Sorry, Lordship, at page 18. 18. Two names are there, Kitab Devrani, Quran.
No, because what we find is that those documents which are certified copies were exhibited,
Yes, Lordship.
and those documents
Extra
which
copies
are not certified copies are marked as annexures.
Yes, Lordship. Yes, Lordship.
Because there is an annexure exhibit mark which is struck out, and then
Yes.
the member tribunal has written as annexure.
Yes, Lordship. That's correct.
So if you have not proved those documents,
Others are proved. Those documents which are marked, those are certified copies of voter list. Lordship. Those are marked. And the voter list of 1966, 1970, appearing the petitioner's father and grandfather's name, those are certified copies. Then 85 voter list, 89 voter list appearing the petitioner's father's name, those are certified copies, Lordship. My father also submitted affidavit in evidence as DW2, Lordship. He was also cross-examined. He stated that the petitioner is his son, is his daughter, Lordship.
but you see the other documents like Gambura certificate,
Yes,
that was not proved.
Lordship, that is, there is also, Lordship, may kindly see the order, Lordship. In
Huh?
the impugned order, Lordship. In the impugned order, it is observed that page 72,
Yes.
page 72, Lordship. Second para, Lordship, may kindly see. DW2, the Gaubura has submitted his affidavit evidence in support of the case of DW1. DW2 further stated that after verifying all the documents of the proceeding, he has issued the certificate in favor of DW1. Lordship, I could not, I have gone through the record.
No,
but
it's
it is
not there.
available there.
You see,
Lordship.
what has happened, the tribunal made a mistake.
Yes,
In
Lordship.
fact, it had, there was evidence of only DW1 and DW2 is the father Quran Ali.
Lordship, Lordship.
And the cross-examination is wrongly written as DW3. That is the mistake committed by the tribunal.
DW next para is DW3 related, Lordship.
Huh?
Father, next para, Lordship. DW3, the
We are
father
telling
of
you,
DW1.
you see this.
That may
I'll show you.
mistake may be there because I could also could not find out that DW.
No, DW2 is the father.
Yes, Lordship.
His cross is recorded as
Three.
DW3
Yes.
in the records,
Yes, Lordship.
when it should have been DW2.
Lordship. Otherwise, Lordship, father has come before the learned tribunal and stated that the petitioner is his daughter, Lordship. That is clear, Lordship, father's evidence.
Mr. Hussain, there are several judgments of this court where we have said, where this court has said that the voters list is not a proof of the sonship or a daughtership. That's one part. Second part is that there is there are judgments that if the to prove the linkage, Supreme Court has said that Gambura certificate should be looked into. But if that is not proved by calling or summoning the Gambura, then there is no connect. You see, it is your case that the names are wrongly entered in the voters list. Therefore, voters list is not sacrosanct. How do you connect?
And that is the ground, anomalies in father's name, as per learned tribal lordship. That is the main ground. Puranali, father's name is differently written lordship, page 73. Mentioned, it starts from page 72, last line. Puran Ali, spelling mistake lordship. Puran Ali, Puran Tali, Puran Abi, Puran Ali Dewan. These are all spelling mistake lordship. This is the main ground why the petitioner has been declared as foreign lordship. Starts from last line of page 72 and continue page 73 lordship, last paragraph. This is the main ground. One more thing. These are all, Puranali is there, spelling mistakes is there, pronunciation. These are all pronunciation. Other name is not there, the Puranali is there, only the spelling mistake, Lordship may kindly see.
That 1951. The language is Puranali, 61 or does it, 61, 66 or does it? So,
Yes, Lordship, and Lordship will see 1966 and 1970 Putra list are almost same Lordship, and discrepancies occurred after 1970 Lordship. Not only name is changing Lordship here, age is also changing Lordship.
But this person came
Yes,
as witness 83 years.
Lordship, but mere statement is not enough, Lordship, and Lordship, he has to at first prove that Quran Ali and present Quran Ali who deposed before the tribunal, he is the same and one
It's
person.
not been
Lordship.
questioned.
Yes, Lord.
That is for the state to raise the objection that you are not the one and the same. Nothing is there. He has given a
And
very
Lordship,
categorical deposition that so and so is my daughter, born in so and so day, so and so village. There's no cross. I mean, no queries put.
so, but Lordship, Lordship, if Lordship, see Lordship, 1966 Putra list, page number 18, Lordship.
Yes.
Here, Kitab Devani is the grandfather, Lordship, Quran Ali is the father.
Is number 18.
18, Lordship.
Yes.
Yes, Quran Ali is the father, projected father, and Kitab Devani is projected father. Quran Ali is at that time
32 years, Lordship. Then Lordship,
No, Mr. Sharma, we are trying to just understand. Let us say an imposter has come to court to depose.
Lordship,
His actual name is A. He has come to court and deposed as Z. Now, ideally, how the fact that the person who has deposed as Z is an imposter can be highlighted. You think yourself to be a trial court lawyer. Now you are facing a witness who's actually A, but deposing as Z. As a trial court lawyer, how would you demolish? Or how do you expose that the person is an imposter?
Lordship.
And what happens if that cannot be exposed? That Z person who is deposing as Z is an imposter. And what happens? Think like a trial court lawyer and then tell us.
Lordship.
You see, even subsequently, there's a possibility of impeaching the credibility of the witness, Z,
Yes, Lord.
by way of filing a criminal complaint. Even subsequently, if you come to know that the person who has deposed is not the correct person, then under 215, sorry, this 295 and 340 read with CRPC. You can still file a complaint and say that an imposter has come. He's not the correct person, and therefore 295 he has committed perjury and led to an evidence. And therefore he can still be prosecuted.
Lordship. Lordship is true, Lordship, but Lordship, here in this case, except the oral evidence of the father, Lordship, there is nothing to prove that she is the daughter of Puran Ali, Lordship. And Lordship, already
But there is already a judgment of this court
yes,
on such
Lordship.
evidence.
Vijayada's case has been settled, Lordship, regarding then. Oral evidence is not enough. Lordship, where 2018 3 GLT 118, Lordship.
2018
3 GLT.
No, after that there is a judgment of taking a different view.
Lordship.
After that there is a judgment taking a different view that once there is no cross-examination,
Lordship,
Abdul Khalik is also there.
no.
you have a copy of the judgment.
I'm sure
After that,
I
Lordship,
can remember that Abdul Khalik.
Abdul Khalik.
Yes, if the evidence is not demonized, it is considered
Why don't you produce the judgment, refer to it? If it is in your favor.
2 o'clock bring a judgment.
yes, Lordship, I can.
Lordship, again, Lordship, here in this case, Lordship categorically stated, Lordship, in under case, Lordship, oral evidence of father, Lordship, how it can be treated, Lordship, before the tribunal, Lordship. WBC 4020 of 2017, Lordship.
4020.
Yes.
Is it
Lordship.
reported? No.
Perhaps it is reported, Lordship, but
What is the name?
Asia Khatun, ASIA KHTOON. WPC 4020 of 2017. Lordship, here specifically stated that the statement of DW2, that is Amiruddin, who claimed to be the father of the petitioner, cannot be relied upon in the absence of any documents showing his relationship to the petitioner. In this, we would observe that in a proceeding under Foreigners Act 1946 and Foreigners Tribunal Order 1964, the evidentiary value of oral testimony without support of documentary evidence.
Just a moment. I see a spelling of Asia Khatun is
Yes.
ASIA.
AHATOON.
Yes, Lordship.
No, I think that's not reported.
AHATOON. Another is
No,
Lordship.
you'll have to produce a copy of the order because we don't have that.
Lordship, one is reported case regarding oral evidence of murder, Lordship.
You are referring to which paragraph? In Asia Khatun?
Lordship, in page 3, Lordship, second paragraph number was not given here, Lordship.
Second paragraph.
Page 3, statement of DW2,
Yes.
that is Amiruddin, who claimed to be the father of the petitioner, cannot be relied upon in the absence of any documents showing his relationship to the petitioner. In this, we would observe that the proceeding under the Foreigners Act 1946 and Foreigners Tribunals Order 1964, the evidentiary value of oral testimony without support of documentary evidence is solely insignificant. Oral testimony alone is no proof of citizenship. The evidence of DW2 does fall short of being considered as cogent, reliable, and admissible evidence, so much so to establish linkage of the petitioner to him. Lordship, another reported case, Lordship, 2023 GLT 347. Here
2020.
2020 3 GLT 347. Here Lordship specifically stated the oral evidence of
What is the name of the
murder.
party?
Lordship Noor Begum, WPC 1900 1900 of 2019.
2020 volume 3 GLT.
2020 3 GLT 347, Lordship.
Here you are referring to paragraph?
Paragraph, Lordship, 6, statement of DW2. Jahrun Begum, who claimed to be the mother of the petitioner, cannot be relied upon in the absence of any documents showing her relationship either to the projected grandfather, father, or to the petitioner herself. Oral testimony of DW2 alone, since any documentary support cannot be treated as sufficient to prove linkage or help the case of the petitioner. Sir. Lordship. Surprisingly, the petitioner failed to produce a single voter list in her name even until the age of 50 years. That is different. We would reiterate that proceeding under the Foreigners Act 1946 and the Foreigners Tribunal Order 1964, the evidentiary value of oral testimony without support of documentary evidence is wholly insignificant. Oral testimony alone is no proof of citizenship, Lordship.
Hmm. 2020. that is the case, then still we need to read it back. We will continue to read the release area. But the evidence is recorded in the record. Hey, then it's in the record. Page 72. Noted. Noted. It's in the- it's in the case. So, I don't see. Steps line. We are showing you this record. You do. We'll ask you to see page 72 of the writ petition. First, see page 72.
Lordship.
Paragraph 2, DW the Gambura.
Yes.
Please read that.
DWD Gambura has submitted his affidavit evidence in support of case of DW1. DW2 further stated that after verifying all the documents of the proceeding, he has issued the certificate in favor of DW1.
Correct.
Yes, Lord.
Now, look at the record we have sent you. Index is there. At least DW3 we did not find. Mr. Hussain also says he did not find. There's the index page.
Yes, Lordship. May orders
DW1,
evidence of
DW2.
DW1, cross-examination of the evidence on affidavit of DW2.
Yes, 3 is not there.
Cross-examination. 3 is not there.
And you check the record, it's not there. We have checked each page of the record.
Yes, Lordship.
It's not there.
Yes. Only further evidence, Lordship.
Yes. So how did the tribunal record the evidence of DW3?
Yes, Lordship.
Now you see the difficulty. You've seen that?
Yes.
Now you see you see this copy, this page. Please come to page number 67 of the petition. Page 67 of the petition is DW3. Right? Now in the record, they have, while sending, they have corrected it to 2.
Yes, Lordship.
You've seen that?
Yes, Lordship. Yes.
Verbatim same, but while sending the record to the High
It was
Court,
corrected, Lordship.
it was corrected.
Yes, Lordship.
Correct.
Yes, Lordship.
So DW3 is not there.
Yes, Lordship.
Now what do you say? What should we do?
Lordship, these are some typographical error, Lordship.
No, evidence is
Yes,
written in the
Lordship.
judgment.
Yes,
It can't be typographical error.
I am seeing, Lordship. Is there anything regarding DW3, Lordship?
No, it is not there. It is not there. Very unlikely that we will miss it.
Lordship.
We give you time till 2 o'clock. During lunchtime, you may read and reread the record.
Lordship.
And if it is not there, then what would be your submission?
Lordship. I will submit that to Lordship.
Okay. Then we rise early, 2 minutes. Well, in 2 minutes, we cannot do any other matter.
If you go from a handling counter evidence. No, evidence of কপিটা তো থাকবে না
Thank you. आपके लिए लेंगे ना
Yes, Lordship, I have seen the record, Lordship. Lordship, I have not seen any evidence of DW3, Lordship. Only TW1 and 2 is there, Lordship.
Therefore, it has to go back. The tribunal has to reconsider whether in the absence of evidence of DW3, whether the observations made in the opinion with regard to that evidence is proper or not.
That can do, Lordship, but Lordship, if in Lordship, although that mistake was done by the tribunal, Lordship, my humble submission is that, Lordship, it will not hamper the merit of the case, Lordship.
No, you see, the records must be straight. There
Lordship.
cannot be an inconsistent record. If the evidence of DW3 is not there, the tribunal could not have discussed it.
Yes, Lordship.
So that part of the tribunal's order has to be bad, held to be bad. We can't say that the opinion is right, but the contents are wrong.
Lordship. Lordship.
Wherever it.
But, so am I Hussain, learned counsel for the petitioner, Mr. G. Sharma, that standing counsel for the Home Department representing respondent number 3 and 6. Mr. H.K. Hazarika, learned government advocate, appearing for respondent number 5 and 7. And Mr. A.I. Ali, learned standing counsel for the respondent number 2. Next panel. Although the state coordinator, NRC, Assam, is under the administrative control of the Home Department, but none represents respondent number, as they said, respondent number 4. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has challenged the opinion dated 19/1/2018, passed by the Learned Foreigners Tribunal number 2, Kamrup Rural at Boko in BFT case number 3555/2016. Next paragraph. By the said opinion dated 19/1/2018, the Learned Tribunal, after discussing the evidence and materials on record, came to a conclusion that the petitioner Rup Bhanu, RUPBHANU, alias Rup Bhanu Nessa, is a foreigner who does not belong to Indian national. Post on. Next one. Having heard the learned counsel for both sides, and upon perusal of the records which were requisitioned from the Learned Tribunal, we take note of the fact that the Learned Tribunal had discussed the evidence of Gambura and the discussion on the evidence of DW 1, 2, and 3 is reproduced as below. Page 72. Blue pencil. Post on. However, on a perusal of the records, it is noticed that the petitioner had adduced evidence of herself as DW1 and her father, namely Quran Ali, has adduced evidence as DW2. Post on. The Gambura was never called for as a witness, and his evidence and the evidence of the said Gambura is also not on record. Full stop. Next paragraph. We also take note of the fact that in Annexure 19 to the writ petition, the document which is annexed is the deposition of witness DW3. First of, however, comma, it appears that reference to DW3 is a typing error, as DW as the name of the said DW3 is recorded as Quran Ali, Kuran Ali, comma, who had filed his evidence on affidavit as DW2. Full stop. However, in the records of the learned tribunal, comma, after issuance of the certified copy within bracket annexure 19, comma, the DW3 is overwritten as DW2. Full stop. From the forwarding index, it is also noted that the learned tribunal, while forwarding the records, has mentioned in the index only about DW1 and DW2. Next paragraph. The learned standing counsel for the Home Department has supported the impugn opinion insofar as it relates to the discussion on the evidence of DW3, sorry, of the Gaura, by submitting that they said observations and discussion of the evidence of the Gaura would not prejudice the petitioner, as the petitioner has otherwise failed to produce any document to connect her to her projected father. Next paragraph. Upon consideration, the submissions made at the bar, comma, the court is of the considered opinion that the discussion of the evidence of the Gaura, comma, which was never adduced, has vitiated the opinion. Stop. The reason for, and as we are of the considered opinion that a discussion of the evidence on record must be based on the materials available on record and not on extraneous matters which are not a part of record. Full stop. The discussion of the evidence of Gaura, which is not there on record, is not sustainable. And therefore, the court is unable to accept that the discussion on the evidence of the tribunal is bad, but the opinion rendered on such discussion is correct. Next, therefore, comma, the court is of the unexistent view that in view of the discussion of the evidence of Gaura, comma, which does not exist on record, comma, the impugn opinion dated 19/1/2018, passed by the learned member, comma, Foreigners Tribunal number 2, Kamrup, within bracket rural, bracket to Z Boko, in PFT case number 3555 of 2016, stands vitiated, and therefore this same is set aside. Next paragraph, the matter is remanded back to the said learned tribunal for his decision. Now again, a question to you,
Not sir.
Mr. Sharma.
Not sir.
You are satisfied with the cross-examination or you want an opportunity to uh,
No, not.
to do anything more? Or you don't say anything? We leave the parties to take such steps as they may be permitted.
Lordship may allow me to cross-examine the,
So we only say that your parties are permitted to do,
yes, yes.
to take
Lordship.
such appropriate steps in the tribunal as they may be so advised.
Yes, yes. Lordship.
Okay. Next one. Next, the parties are at liberty to take such steps before the learned tribunal as they may be so advised.
Yes.
Next, the petitioner shall without fail, shall, comma, without fail, comma, appear before the said learned tribunal on 14/11/2024 and by producing a certified copy of this order, await for further instructions from the said learned tribunal. Full stop. Issuance of a fresh notice on the petitioners by the learned tribunal is not required in view of the directions in view of the aforesaid directions. Full stop. Next para. In the event the petitioner fails to appear before the said learned tribunal or cooperate with the proceedings, comma, it would be open to the said learned tribunal to pass such orders as it may deem fit and appropriate.
On the basis of materials available on record. Lordship. On the basis of materials available on record.
We are not
Lordship.
saying anything. On the basis of materials available on record, then you can't recross him.
Yes. Lordship.
And on the basis of materials on record, you don't even need our observation. But you don't default. We have dispensed with the appearance notice. And we have also observed that non-appearance will entail. And again, next para. The order of bail as granted on 21/2/2018 to the petitioner shall lapse on 14/11/2024. This is an insurance. Keep the amount to the extent as indicated. The records are returned.
Item number 11 to 28.
Wait, please, Lordship. Lordship, item number 11, I am appearing for Dima Asa, Lordship. In this matter, I have to provide some instructions, Lordship. That has not, we have not received it yet, Lordship. Sometime may be granted, Lordship.
No, but the issue is regarding the pension.
Yes, Lordship.
Pension.
So if you are not getting any instructions, we'll have to summon the officials.
No, Lordship. Actually, what has happened, the office has shifted, Lordship. So their files, they have not found the files, Lordship. 1 week time, Lordship.
Only 1 week's time.
Of course. Em hay con el café lo puedo seguir y pues algo de
Yes, you got it, one is fine.
No.
Okay, both sides are represented. On the pair made by Mr. C. Sharma, rather standing us for the Dimahasa Autonomous Council.
Oh, direct.
You're there only in one item,
Yes, Lordship, item number 11.
11. In WA 356 of 23. All the matters stands adjourned today. Next one. After we give a date, list on so as prayed for. You just say all sides are represented. We are recording presence of all sides. 6, 11, 20, 25.
Yes, Lordship.
May it please your lordship.
Yes,
Lordship, with the consent of father side, I beg to mention item 2.
item
2, lordship.
2.
Here, lordship, I'm led by K.N. Chaudhary, sir. He's having little inconvenience today to place his argument. So may I pray this matter may be posted on 30th of this month, lordship.
No, 30 is a motion day. We are saying it on the week commencing 28. We are not fixing a date
Lordship.
because we are otherwise taking up a division bench. So the registry, let the registry check out the date and place it
Next week.
next week.
Yes, lordship.
Because there are only few matters in the single bench, so therefore
Okay.
let them do it.
Lordship.
Both sides are represented. On the prayer made by Ms. T. Son, learned counsel for the petitioner, the matter stands adjourned today. The registry shall list the matter in the week commencing 28/10/2024. Or next week, you can say.
Next week.
Next week.
Next.
They should be the matter. Any date next week.
And the progress. May it please your lordship. Lordship, I pray for listing a review petition. Lordship, next week.
Review of the order passed by me.
Yes, lordship.
Okay, give the slip to the court master.
May I please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 1, lordship. The matter
Yesterday
may-
memos was submitted.
Memos
Okay.
submitted. Lordship, the matter may come in the last week of November, lordship.
We're fixing it after 2 weeks. We can't give a long adjournment. It's a part-heard matter.
Lordship, can it be 3 weeks, lordship? Mr.
No,
Bhatti's-
part-heard matter, we can't hold it. You know the High Court rules.
Yes, lordship.
Both sides are represented on the prayer made by the counsel for the petition of the matter stands adjourned today. List after 2 weeks on a date to be fixed by the registry.
Published.
Meet with your lordship. Lordship, I beg to mention item number 11 of today's daily list. Lordship, there is some
Okay.
difficulty.
Yes. Okay. Both sides are represented. on the prayer made by learned counsel for the opposite party. The matter stands adjourned today. List on
Can it be on 29th, Lordship? 29th of
list on
October.
29/10/2024.
Much obliged, Lordship.
Daily list item 3. Bill hearing.
Lordship, can we see the last order, my lord? Regarding that new act, my lord, Bads Act, my lord, unregulated deposit case, my lord.
Ah, yes. You are appealing for CBI chief? No.
I have made my
You are
submission
there,
earlier.
please.
Because I got CBI Lordship.
So. Will produce your
Lordship,
status of investigation?
no, Lordship, I have no instruction, Lordship, with regard to transfer of the case, this case to CBI, Lordship. Though there is a notification, Lordship, I have got the notification, but the handing over and taking over the case diary, Lordship, is not known to me, Lordship. But they served a copy to me yesterday, Lordship, bail application, Lordship. So, Lordship,
By when you will get information?
2 weeks time may be granted, Lordship.
This is a long time because I'll have to call for the investigation report. If you have taken over, 2 weeks will be again too late.
The difficulty is that, Lordship, I have no instruction as such.
No, that's
because
okay.
There are several branches. The cases were distributed to those branches, Lordship, not only a single branch, Lordship. It is not that all the cases were handed over to CBI Guwahati branch. Some cases were handed over to CBI the EO branch, Economic Offence Branch of Delhi. Some cases of economic offence too. So likewise, it was distributed. So this case, which branch, Lordship, I have no idea, Lordship. I cannot collect also that information, Lordship.
No.
We give you a week's time to try to get
Get into
information.
the
If not,
offense, eh?
you seek for extension of time.
Lordship.
1, 2, and
My lord, in the meantime, can there be protection? Because my lord, see,
No, because you understand the position now.
that is true, but kindly see the scenario, my lord, because
No.
Assam,
Mr. Chaudhary, that's not the point. The point is that somebody must with instructions object to it.
that is true, my lord, only
But
thing.
who will object
But
if
that is so much-
if he has no instructions?
No, but kindly see, my lord, because that notification, it's your lordship discretion, I have nothing to say. Kindly say the notification is of possibly on 8 or 9, my lord. So now today is, well, 2-3, my lord, weeks in the meantime. So till that, it is hanging, my lord. And if, kindly say, my lord, if somebody was arrested, so what will be his, my lord, course of action, my lord? Although it is a
No, if-
438.
If somebody is arrested, Mr. Chaudhary,
Yes.
then we have a police case number and we know where the case diary is.
My lord.
But now we are in a situation where the state government has handed over the investigation to CBI.
Yes, ma'am.
The counsel for CBI says that he has no instructions because of the fact that which department has taken over, we don't have.
Article 21, my lord. In the meantime, then, my lord, kindly, my lord, because, my lord,
No, not
If-
not without.
if
giving-
nobody is, if
giving
they say,
opportunity.
if they say till 4 weeks, there will be no, my lord.
No,
nothing.
that he can't say.
Lordship, let the matter be Because fixed on
That-
4th of
that he
November,
can't
Lordship.
say.
4th of November, I'll take instruction. I'll Because try to take instruction, Lordship, because I don't know, Lordship, What I meant, because, my whom to lord, approach, Lordship, which branch I'll have to
If it
approach.
if it was somebody in jail, my lord, he could not have, or we could not say that it will be kept in
That
hand.
is a different situation.
No, I
You all
understand,
know-
because it's a, my lord, police case, so.
And you know more than us.
No, my lord, no, my lord, no. That is not, my lord, but what I meant, my lord, that definitely, my lord, he will take some time, but
But instructions must come
next-
without granting, we have so many authorities which say that
yes, ma'am.
without giving an opportunity to the APP, bail cannot be anticipated, PS bail cannot be granted.
Then another, that Gurbaz Singh Sibba, my lord, without FIR also, my lord, lordship has the power, my lord, that is also there, my lord, so it's a,
No,
my lord, balance has to be made, definitely, my lord, but only thing what I meant, my lord, because fortunately it is 438, otherwise, my lord, 439 hanging, my lord, in.
no, that's okay. So we can't help it.
co-equity is already granted, that's why, my lord. Otherwise I would not have prayed, my lord. Co-equity is granted by
I
this
understand,
honorable court.
no.
Because there is no progress of investigation, my lord, as they have already stated, my lord. That's why, my lord. Otherwise, I also would not have prayed, my lord.
Mr. E. Chaudhary and counsel for the petitioner is present and expresses urgency in the matter. Next paragraph. Mr. D.P. Goswami, Learned APP for the state is present. His contention is already recorded in the order dated 21/10/2024. Next paragraph. Mr. M. Haloy, Learned
Special PPCB.
Special PP for the CBI has entered appearance and has submitted that he has not received any instructions as to which branch of the Central Bureau of Investigation has been entrusted with the investigation and prays for at least 2 weeks' time to obtain instructions. Next paragraph. As the investigation of Nagaon PS case number 859 of 2024 has been handed over to the Central Bureau of Investigation by state notification dated 9/10/2024. Court is inclined to grant only 1 week's time to the special PP, CBI to obtain instructions. Next paragraph. The learned special PP, CBI is granted liberty to send the downloaded copy of this order to the office of the CBI Guwahati to enable the said authorities to provide proper instructions to the petitioner. Sorry, to the learned standing counsel, special counsel, special PP. Next paragraph, list on, give a date after 7 days.
Here, my lord, the act, my lord, act says, my lord, there has to be one competent authority of section 7, my lord. And competent authority can send, my lord, that is section 30, my lord, in a given situation where it is, my lord, depositor from outside state or of such magnitude that amount, my lord. So possibly all case may not be taken up by them, possibly. Because that act itself is clear, my lord. And whether a competent authority has been appointed or not, we also don't know. Or because it's a special act, my lord.
No, but not on presumption. We rails will be very slow in doing that.
That is true, my lord. But from 8 till, my lord, now, my lord, nothing is clear, that's why.
We have given a specific direction.
Yes.
You will give it the order to the CBI Guwahati.
Yes.
They will collect information and give it to him.
Yes. Much obliged.
Yes, item 4.
I will receive some instruction in this case.
In pursuant to the last order, my lord, some specific query was made to the, my lord.
Some
They
instruction I received also.
received the instruction, and the day from the instruction I came to know that near about 72 posts were lying vacant, and that was advertisement, early advertisement, because 31 not joined and 41 did not turn up. Those who were selected in that selection. In that aspect, my lord, they want to file a affidavit.
That's why last recruitment, the department will have to decide at the higher level.
Lordship, yeah.
And last
So
time
they want 2 weeks time, Lordship, to decide to clear picture, Lordship.
You are therefore requested
No,
to
no,
kindly place the matter
Mr.
before the.
So, Padhya, you see, it was a very simple issue. Whether the vacancies which are notified, which arise post first requisition,
Yes,
will have to be treated differently.
Correct.
yes, Lordship.
You can't have subsequent vacancies adjusted against the first
You cannot.
notified vacancy. It can't.
Cannot be, Lordship.
So I don't know why your authorities are taking so much of time to.
My lord, no, actually, my lord, I want that, my lord, at least they should file a affidavit. Because earlier also in my lord, they did not give the clear picture before this honorable court, my lord. No, did not even file a affidavit, my lord. In that case, that's why, my lord, even my lord, this content also, my lord, they can.
No, you are right, Mr. Mantra, but
Done, because-
see, every time I read this, I think it would be a better case for a appeal rather than review.
I understand, but if I go for appeal, then my lord, actually, I try to find out a solution, my lord. I actually, my intention is to, my lord, to file the review petition to find out a solution to accommodate them, my lord.
I understand, we took note of that
Because
earlier, but
otherwise, yes, I can easily, my lord, file a appeal, but I honor the judgment, my lord. I try to, my lord.
no, that's good, but I am not finding a solution. In fact, we've not been able to formulate.
No, my lord, if they say, my lord, in the affidavit that these are the vacancies there is, and if your lordship,
It can't be acceptable. Subsequent adjustment may not be acceptable. Let them file an affidavit. and
Lordship,
see.
Lordship.
actually, my lord, there is a order from this honorable court to keep the vacancies
Kept vacant.
my lord, in their interim order was there. So according to them, my lord, that by that order, my lord, whether they have kept it vacant or not, that has to be reflected, my lord.
Okay. Mr.
I'm just having one anxiety, your lordship, that the short date may be given, lordship,
No,
because
just 1 week's time. 2 weeks time. That's.
it's convenient to this court because this is not a regular bench. I understand that. Lordship.
So we understand, but you see the situation.
Yes, lordship, I understand. But we are the ultimate sufferer.
Neither we can say yes, nor we can say no.
Though there was
Yeah.
vacant.
I'm sorry, sir.
No, it's okay.
Matter was going on in court.
No, it's okay.
My lord, in this case, we say,
No, they are taking 2 weeks time more
okay.
because Mr. Chaudhary.
But apparently posts are there, my lord.
No, the issue is another. We were just discussing about that only. Last time also we made a reference to it. You see, let us take a artificial date. 1/1/2024 is the date on which vacancies are notified and APSC is requested to
Make selection.
To make selection. Now, any vacancy which arises on 2/1/2024 must naturally go to the next selection.
Future, that's a future vacancy.
Future vacancy. That is why I'm just thinking aloud. We're just thinking aloud so that I can get an answer.
I think, my lord,
Therefore, I got a view.
Yes.
Therefore, I am of the view.
Yes, my lord.
That appeal would have been rather better than a review. And Mr. Monto is also right in his way. He says that he wants to find out a solution. Mr. Chaudhary.
My lord.
Mr. Monto is fairly submitted that he wants to find out a way if this, in view of the vacancies, whether the petition can be adjusted.
Yes.
So therefore, he is not adverse to you at the present.
And communication.
My lord, I think yesterday while preparing, I came across a document. Even among from the select list, my lord, not to speak of future vacancies, there are lot many posts which have people who have not joined.
Yes,
No, that is true. But the select list was never extended. So naturally, if somebody does not join, the selection would, the process would be over.
No, my lord, if a litigation is going on and if a person is approached during the validity of the list, then the list never expires, my lord, qua those applicants or petitioners. That's the law, my lord, that's the law of the land. If somebody approaches the court when the list is valid, then despite validity of the list during the pendency of the writ petition, the list does not, my lord, evaporate. It continues qua those petitioners, my lord.
Okay, that's why we are
Yes.
seeking 2 weeks more time to take a decision. Mr. TJ Monto, Learned Senior Counsel.
My lord, sorry, 1 minute, my lord. One RTI reply was given by the department, my lord. There they clearly say, as per the result published by APSC dated so-and-so 22, candidates bearing, there are as many as 42, my lord, did not join irrigation department.
Yeah, that's not disputed.
Yes.
Here also they say that, same thing.
Not only that, 72.
No, irrigation department. Oh, irrigation, no.
Try to find out a solution.
The vacancies are there. But they want to take a decision and come back.
My lord, I follow.
Senior counsel assisted by Ms. P. Sharma, counsel for the petitioners is petitioners and as well as Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. D. J. Das, counsel for the
Respondent 1, 2, 3.
respondent numbers 1, 2, and 3 are present. Next paragraph. Mr. N. Upadhyay, learned standing counsel for the irrigation department, produced a copy of instructions dated 23/10/2024 received by him, by which the authorities are seeking 2 weeks further time to furnish a clear picture. Full stop. Next para, the learned senior counsel for the respondent numbers 1, 2, and 3 expresses urgency in the matter. Next para. Be that as it may, in view of the prayer made for a 2 weeks time, or the said prayer is allowed. List after 2 weeks on a date to be fixed by the office.
Miller, deep.
Please make a mention if it is not.
My lord.
Because the bench is taking up division bench, so please make a mention if it's not listed. Not required. You, because you'll have to file an affidavit.
Yes,
This
better.
Item 5.
Deeply obliged.
Lordship, here in this matter, Lordship, this morning, Lordship, Mr. B. Chaudhary has requested me to seek some time, Lordship, due to some medical emergency. He could not be here today before this court, Lordship. He has to obtain instruction in this matter for the SLRC department.
Yes.
And Lordship, on behalf of the health department, Lordship, I am appearing on all the matters, Lordship. In item 6, Lordship, I have received instruction. I'll be filing my affidavit. Rest, Lordship, instructions are awaited, Lordship.
Item 6.
Yes, Lordship.
And in other matters,
Lordship, instructions are awaited, Lordship.
Mr. Roy, we give them some time. Mr. S.K. Roy and counsel for the review petitioner is present. Next one. Mr. D. Upamanil and standing counsel for the health department submits that he has received instructions in review petition 143 of 2024. Just a moment. Pass separate orders in all cases. This paragraph is only for item 6. The para now I am dictating. It's only for item 6. In others, they will be different. This will only be in item 6. And accordingly, he prays for, and it's granted 2 weeks time to file affidavit. Full stop. The next para will be common for all cases. Mr. D. Upamanil and standing counsel for the health department prays for, and it's granted 2 weeks time to obtain instructions and file affidavit in this matter. Stop. On behalf of Mr. B. Chaudhary, learned Vikram V. Chaudhary, learned
Standing counsel.
standing counsel for the SLRC, comma has also prayed for 2 weeks time on his behalf to obtain instructions and to file affidavit in opposition in the matter. Full stop. Next one, prayer for adjournment is allowed. List after 2 weeks on a date to be fixed by the office.
Other departments
stop.
are also
Next
there.
para.
They will also.
The affidavits of the respective respondent departments shall also be filed by them. Now record the presence of others, Mr. C. Sharma
For social justice,
for
social justice and empowerment.
their presence, Mr. C. Sharma, standing counsel for social justice and empowerment department. Miss Miss
Secondary.
P. Terangpi, Leonard, standing counsel for
Secondary department.
Secondary Education Department, Ms. S. Sharma, Mrs. S. Sharma, standing counsel for the
Item 6.
PWD.
Item
This
six.
will be in item 6,
Item
her
6, yes.
presence. Mrs. S. Sharma in item 6. And Mr. R.K. Talukdar, London Government Advocate. His presence in all cases. Okay.
Item 9 already.
Amen.
Highly obliged.
This will be item 5 to
9.
9.
Highly obliged.
Mr. Upamanya.
Yes, sir.
I saw you, I just remembered, my aunt has recovered very fast, very well.
Nice.
She's far better now. You see me saw that time,
Yes,
and now she's
she has recovered.
recovered. Not recovered, but substantially she's doing good.
Item 10,
My lord, we have filed this review application. Perhaps, my lord, in terms of the scheme of the rules, they'll have to do the whole thing again, my lord. If your lordship would kindly come to the rules, my lord, regulation, that your lordship will find at page number 259. Sorry, 252, my lord. Oh,
252.
Your lordship's order, my lord.
Yes.
To avoid any delay, petitioner is directed to produce a certified copy of this order along with his written statement within 5/7/24, either physically or through email addressed to the competent authority. On receipt of the same would place it before the ICC for passing an appropriate order to order production of witnesses and grant opportunity to the petitioner to cross-examine the witnesses on such days as may be fixed. It is reiterated that it would be open to ICC to deny adjournment to the petitioner. Only thing is, my lord, from what stage, I think that is not clarified, my lord, because under the relevant service rule, it has to be done in presence of the, my lord, petitioner.
The recording of evidence also?
Yes, my lord.
Where is that?
Yes. 259, my lord. That's 6/11.
259.
Yes, 259.
But then what happens if somebody deliberately does not come on each dates? I'm just asking a hypothetical question. Supposing there is a,
Sometimes somebody might attempt some bitsy, but that can be taken care of, my lord. Please come to 11, my lord, at 259.
yes,
On the date fixed for inquiry, the oral and documentary evidence by which articles of charges are proposed to be proved shall be produced by or on behalf of the disciplinary authority. The witness produced by the presenting officer shall be examined by the presenting officer and may be cross-examination by on behalf of the management staff. The presenting officer shall be entitled to re-examine the witnesses on any point on which they have been cross-examined, but not on a new matter without the permission of the inquiry authority. Inquiry authority shall also may also put such question to witnesses as it thinks fit. Only this much, my lord. I think they will have to, even the witnesses will have to be present because at that point of time I was in jail, my lord. I was in
no,
custody.
but here it says 11 on the date fixed for inquiry.
Yes.
The oral and document evidence by which articles are proposed to be proved shall be produced by on behalf of disciplinary authority. Now, here it doesn't say the recording must be in the presence of the officer, delinquent officer.
It is necessary. Otherwise, my lord, when I'll get an opportunity to cross-examine, then I must be present, my lord.
On the date of cross-examination,
No, my lord, question is like this, it's not that they will give evidence on affidavit. So he will produce a,
Now the evidence is already on record. The cross-examination will be only on the evidence tendered.
oh, that is what, my lord, I think that evidence has to be in my presence. That was only
That
I
is-
was,
That is something which I am not finding.
the witness produced by the presenting officer
Shall be examined.
shall
by the
be
presiding
examined
officer.
by the presenting officer and may be cross-examined by on behalf of the
So
management
it
staff.
can be on the next day also. Means,
So it could be next day, the following day, but in presence, I think, my lord, normally it has to be in presence, my lord. That is what I was only
something-
thinking, my lord.
but that would be, that would be incorporating something in the rule which is not there. That the witness must be, in chief must be recorded in the presence of the,
Normally that happens, my lord. Normally in a trial, the accused will be present. Accused will be present always, my lord.
no,
On the day of,
no. He can be on representation under 205.
no, but at the stage of evidence, he has to be present, my lord.
No. It's not mandatory. The present, it can be recorded and the cross-examination for cross-examination, it can be deferred. So this witness will have to come again to face cross-examination. Like for example, in the cases which are sessions tribal, and evidence can be recorded by the court and the cross-examination may be deferred.
Deferred.
So the presence every time is not required in, even in a criminal trial. That is my limited understanding.
No, no, no. I'm not disputing that, my lord. I was only.
No, I'm saying limited because you see a gap between there and here.
I was only trying to call out a meaning from this sentence, my lord.
No, because then you see what happens is that I'm just thinking aloud. I'm not making making an opinion. You see, even if I ask you with all your articulate abilities to repeat the same sentence tomorrow, maybe there will be
Some difference.
some difference. And then in a criminal trial or in the
matters a lot.
tribunal, it matters a lot. Then you will say that you have done improvement. So I am thinking on that that aspect, that if tomorrow somebody questions that now you are improving, then there's no answer to it. The evidence either is required to be expunged completely
Or
or
just be treated as it is.
as it is, and then you have your opportunity of cross-examination. I think that would be more appropriate.
I think, my lord, having regard to the background, I was in jail. This
No,
all
I
these
understand
matters.
that, but we'll have
Nothing-
to formally issue a notice.
Yes, yes.
Do you concede to the prayer of Mr. Chaudhary?
No, Your Lordship, we have only received the petition as of
I think
yesterday.
possibly, my lord,
We'll
my
need to
our
obtain instruction.
senior, Mr. Mili Hazarika would be in a better position to say that.
Okay, we just issue a notice.
Yes, yes, man, at this stage.
Returnable when? How much time?
3 weeks, Your Lordship.
3 weeks, okay. Mr. K. N. Chaudhary, Tarek Shia Council, assisted by Mr.
M. Gautam.
M. Gautam, has submitted that the review is, that this review petition is limited to consideration by the court as to whether the examination of witnesses done so far should be in the presence of the petitioner, should be redone in the presence of the petitioner, or for a clarification as to whether the cross-examination would be on the basis of examination already done so far. Next para. Mr.
D. Khan, Your Lordship. D. Khan.
D. Khan, the counsel for the respondent number 1 is present. Next para. Issue notice returnable in 3 weeks. You have got copies?
Yes, Your Lordship.
Full stop. Objection, if any, be filed at least 2 days prior to the next date of listing. List on, list after 3 weeks on a date to be fixed by the registry.
Deeply.
Mr. Chaudhary?
I think we'll have to take steps on the private, we'll take, my lord.
Such steps
Yes.
required. I did not see
No, no,
that.
no.
Okay. Next one.
Respondent number 5.
The petitioner shall take steps
on 4
4 and 5.
No, but then word 1 to 3.
Oh, I'm representing 1 to 3, Your Lordship.
1 to 3, then make it, Mr. Khan, 1, 2, and 3.
Mona Lisa has to complain.
Next, the petitioner shall take steps within 2 days.
I think 4 my learned friend can take, my lord. 5 is the complainant.
Four also.
Okay.
The notice has to
Huh?
be issued.
The internal committee is your committee.
It's your
Yes,
committee.
but it is a separate standing from NRL, your lordship. So that's why the notice has to go from the court, and thereafter, maybe if they like, they can engage us.
Anyway, we'll take
thereafter.
steps.
Okay, petitioner shall take steps within 3 days for service of notice on respondent number 4 and 5 by
Yeah,
registered
that's
post
what
EDD. The learned instructing counsel for the petitioner shall have liberty to collect the postal receipt number and to submit postal track report prior to the next date of listing. Next paragraph. Same thing, list after 3 weeks on a date to be fixed by the registry.
Deep level.
Mr. Chaudhary, I'm not fixing a date because
No,
I'm
but it's all-
taking a division bench.
I know, lots of is now heading a different place.